Hello, everyone. Hopefully you can all hear and see me. Um, my name's Aidan O'Brien, and I'm going to speak to you this afternoon on the topic of getting the best from medical experts. This is the latest installment of the Farrar's Building webinar. We're hosting these webinars on various topics every fortnight over the coming months, just to let you all know that we will email you a video recording of this webinar and the associated slides after the event. In addition to that, whilst I'm talking, if there are any questions that spring to mind from any of the participants, feel free to ask those questions. I won't be able to hear you articulate those questions, but you should be able to see at the foot or perhaps at the top of your screen, there is a Q&A function. If you can type your questions in that Q&A chat, at the end of what I'm about to say, I will read out relevant questions and try and give answers to the best of my ability. If you don't want to leave your name when leaving a question, that's absolutely fine. Anonymous questions are no problem. So everyone, I think we've probably got as many participants as we're going to have. So what I will do is share my screen again and try and get some slides up. So do bear with me one moment. Great. So you should all be able to see the first introductory slide. As mentioned, my name is Aidan O'Brien. You'll see that my email address is on this slide. It's also at the end of the talk. I've left that there because I'm certainly more than happy to field any questions after this afternoon. So if something crops into your mind that you wish you had have asked me, 3 o'clock in the morning, if you wake up with a burning inquiry, feel free to send me an email, perhaps not at 3 in the morning, but at a reasonable hour of the day. Just by way of background, I am obviously a barrister practicing at Farrar's Building Chambers. I specialise in clinical negligence and personal injury work, both for claimants and defendants, so a bit of a gamekeeper as well as a poacher. In my talk this afternoon, I'm going to try and make sure that it's as relevant for practitioners who perhaps specialise in claimant work as well as practitioners who perhaps specialise in defendant work. In addition to that, whilst some of the examples or some of the issues I may be talking about may appear to be specific to clinical negligence work, I think those practitioners who exclusively practice in personal injury will also hopefully take something from this talk. Many of the principles are transferable or just as relevant. And of course, in any personal injury claim, a practitioner should be alive to the possibility that there may be issues of clinical negligence where an injured party presents to a medical institution and receives treatment. And one should always be thinking in the background as to whether contribution proceedings or a break in the chain of causation are live issues in your case. So hopefully this talk will be relevant for claimant defendant practitioners doing both PI and clin neg work. So first things first, why is medical evidence so important in these types of work? Well, this is pretty obvious, should be pretty obvious to all of you. Good medical evidence is critical to the success of each of your cases. Your liability experts will often determine whether you're going to win or lose a case, and so it's critical you ensure that you've got the best expert evidence possible to put your best foot forward in a case in respect of liability. But also, when it comes to quantum experts, getting these experts involved in a case and ensuring that they produce robust, persuasive reports can significantly alter the value of a case. So for example, I've got on screen there the question of whether private medical care is warranted in a case. As many of you will appreciate, a claimant when injured will often plead losses, future losses, which include the cost of private medical care, as they are entitled to do. But there may be some issues about the practical realities of whether they will in fact receive private medical care in the future. This issue, discrete issue, can have a significant bearing on the value of a claim. I was recently involved in a case which involved renal disease or damage to the kidneys, where a claimant was going to need dialysis and potentially a live donor transplant in the coming years. And there was a significant dispute between the parties as to whether she would in reality be subject to private or state provision for that medical care. The difference in value between those two alternative scenarios was about £3 million. So just on that discrete issue, a huge difference in the value of a claim. And that issue turned entirely on the views of one set of particular experts. So we're trying to get the best medical evidence, or getting the best out of a medical expert. The first and obvious thing that a practitioner needs to do is to identify the correct medical specialism that is required. Now, that's not always as simple or as obvious as you might think. There will be a large number of examples where it's pretty clear that you, for example, need an orthopedic surgeon because someone's broken their leg, and you want them to either comment on condition and prognosis, or if it's in a clin-neg context, perhaps the way in which that injured person was treated once they presented to hospital. But there will be a large number of cases where, in fact, you need more niche, lesser known subspecialisms or particular specialisms. And it can be difficult to really know from a standing start who is the right expert to instruct. The most obvious point to make is, well, sometimes Googling a particular type of injury can reveal quite a lot of information about who is the relevant type of specialist. Asking colleagues is also very useful if you're unsure, but also if you have been in contact with experts, or you're thinking about instructing a particular expert, I wouldn't be shy about saying to that expert in a very upfront way, look, not entirely sure if you are the ideal expert to comment on this. If not, can you recommend a particular specialism which is better placed to speak about it? And most experts will be very generous with their time in terms of responding to that and pointing you in the right direction. Perhaps more importantly, or a way in which we can get things wrong perhaps more frequently, is to fail to appropriately consider the best expert within a particular discipline or field. So the example I've given on screen there is to say, well, not all orthopedic surgeons are equal. The most obvious example of that is if you do have a case involving someone breaking their leg, so a lower limb orthopedic injury, you may not want to instruct an orthopedic surgeon who specializes in wrist injuries. Pretty obvious point. Whilst that expert is, of course, generally competent to speak about orthopedics, they may not be as powerful or convincing a witness as the experts that the opposing side instruct, who may well be a specialist in lower limb injuries. As a really good example, albeit a quite unusual example of this, I was recently involved in a clinical negligence case which involved an Afghan war veteran. Now, that claimant had suffered historic injuries to his feet due to an IED explosion. Now, those injuries were healing and subject to rehabilitation at the time of the Index accident. The Index accident was an accident he suffered whilst manning a yacht for a charity Help for Heroes type race. At this stage, he was still within the rehabilitation period of his lower limb injuries. There was some question about how well he would recover from those IED injuries. Unfortunately, whilst on the yacht, he broke his leg. He presented to hospital, and there was an alleged failure to appropriately treat compartment syndrome. Now, as a consequence of that, it's alleged that he was required to undergo an amputation, which would otherwise have been avoided. Now, the defendant's case was that, in fact, the IED injuries were failing to rehabilitate as successfully as hoped, and that this soldier would have, in fact, undergone an amputation in any event. He would have eventually decided and elected to have undergone an amputation to achieve a better functional outcome. So much of this turned on the question of how this claimant was likely to come out of his IED rehabilitation. And as perhaps you can all imagine, most orthopedic surgeons in the UK don't see IED type injuries in their day-to-day practice. It's quite an unusual type of injury, a blast injury coming from below. And so whilst they can give an opinion, and perhaps a very cogent opinion as to their expectations in respect of that patient's recovery, they're not perhaps as well placed as the expert who was instructed by the claimant in that case. In that case, the claimant instructed an orthopedic surgeon who was based in Headley Court, which is an army rehabilitation centre. That orthopedic surgeon essentially specialised in war injuries. That was his bread and butter, to look at these injuries, treat these injuries, and he would have a wealth of experience in seeing how these injuries resolved over a prolonged period of time. So he was much better placed, the argument went, to comment on the likelihood of this gentleman requiring or electing to have an amputation but for the yacht injury. And that was a really clear example that I've encountered where the claimant solicitors in that case really did their homework, and before instructing an expert, they not only identified that they needed an orthopedic expert who specialised in lower limb injuries, but also they understood that there was essentially a subspecialism beyond that of orthopedic surgeons who dealt with war type injuries. And so they got one over really on the defendant in a tactical sense at an early stage in that case. Right, in terms of what makes a good expert, well, there's a couple of fairly simple rules of thumb that you can always follow, or certainly you should. So for example, often people overlook the fact that if you're asking an expert, for example, to comment on medical care received, so in a clinical negligence context, it's important to ensure that your expert was in practice at the time of the alleged breach of duty. So for example, you may instruct a nursing expert to comment on the standard of care, breach of duty in a particular case. But you may find on closer inspection that your nursing expert has been retired from frontline practice for the past 15 years, whereas the alleged breach of duty occurred a mere 3 years ago. And that nursing expert is not as well placed to comment on the applicable standards, conventions, approaches as an expert who is either currently still in practice or retired from frontline practice a short time ago. So it's certainly not wrong or even a bad thing to instruct an expert who has retired from frontline practice, but please just make sure that they do have relevant experience of the practice that pertained at the relevant time. In addition to this, and it's a fairly obvious point that most people will be aware of, is you need to make sure that your expert doesn't have any conflicts of interest. Now, I suspect that many of us look at an expert's report, and when the expert has accepted the instructions and has written that line that we often see in the report saying, "I don't know of any conflicts of interest," we probably don't look at things much more closely than that. But I think it's certainly right to really push your expert at the outset to confirm that they don't know of any of the central protagonists in a particular case, because I think often experts fail to appropriately turn their minds to this issue in perhaps the way they should. I have encountered a number of cases recently where there have been issues in respect of conflict. One in which a particular expert was the treating physician dealing with the claimant in the fallout from their alleged injuries, and certainly had developed a close relationship with that claimant, and in that sense was probably quite easy to attack in terms of their objectivity. A more alarming example is another case I dealt with a few years ago, where we were at quite a late stage in a case. I'd been instructed to hold a telephone conference with the experts, which went unremarkably as far as I could tell, until the last few moments, where the expert, who was a very preeminent professor, said something along the lines of, well, when I trained Mr. Smith a number of years ago, he was much better than this. And that obviously gave rise to the question of, in what way did you train him, when did you, and the like. And all this stuff hadn't been disclosed and was certainly relevant in that instance. So I suppose the warning I'm giving everyone is, don't rely or don't assume that there are no conflicts with your expert just because they've accepted the instructions or they haven't properly flagged it up. You should just ask and make sure they've got to think about it, switch on their mind before proceeding with them. I'll change slide now, if you bear with me. Couple of rules or practice points which I think are really useful. First of which, I know all my colleagues do this and I do this, try and keep a list, or certainly try and remember good experts when you come across them. That's whether you come across them when they're on your side or when they're on the other side. A good expert is just invaluable. Someone who communicates well, clearly, with authority and with, I suppose, gravitas, either on paper or in person. These are the types of experts that you want to be using. You want to avoid the duds. You want the tried and tested experts. So if you've had a good experience, just try and record somewhere the name of that expert, the contact details, their particular subspecialism and where they're based, the geographical area where they accept instructions. Also remember that many of you will work in firms where you've got lots of colleagues dealing with a similar type of work. And I would say, don't be afraid to ask colleagues whether they've got recommendations, particularly if you're stuck trying to find a particular discipline. In addition to that, feel free to contact counsel or counsel's chambers. I know my colleagues and I in Farrar's building were frequently sent emails by our instructing solicitors just asking for a bit of a tip. Who should we instruct in this particular case? Can you give us some recommendations? We get emails sent to the clerks generally, or sometimes personally, and none of us mind fielding those calls. We're more than happy to help. It's no skin off our nose. It's very quick and easy to respond to those types of emails. So don't be shy about doing that. Something I think is particularly useful to do, particularly in cases where it's quite a high value case and you want to be absolutely sure that things aren't going to go terribly wrong later down the track, is to do a brief search on Lawtel or Westlaw, any legal database, for the name of your expert. As you'll all probably appreciate, you can search Lawtel and Westlaw with keywords or just search terms, so you can include the name of a particular expert, and you can see cases that have gone to trial where they've been involved, and you can see which way the case has fallen. Not that that necessarily dictates how good an expert that person is, but you can also sometimes see there have been instances where your proposed expert has been criticized by judges. Now, it's relatively rare for there to be excoriating criticism of an expert from the judiciary, but as a salutary warning, perhaps I'll just put up on screen an extract from a judgment in 2016. I don't want to embarrass this expert, or certainly ex-expert, but perhaps if you take a bit of time just to cast your mind over that text, you'll see that the judge in this case was, I'm trying to find the right term for this, very critical of this particular expert, and noted the fact that in a recent case, previous case to this one, similar criticisms had been made of this well-known, apparently well-regarded expert, who many of you may have instructed in the past, or certainly may have come across. This was unfortunate for this medical expert, and I think it was probably terminal for his medical legal career. In case any of you are wondering what this expert is doing now, a quick Google search reveals that he has decided to reinvent himself as a World War II Hawker hurricane display pilot. This article is from 2016, so quite soon after those two judgments. I'm not sure if there was any connection between those criticisms and the decision to move into a different field. Let's hope this neurosurgeon is a bit more conscientious in the way he flies his planes. Anyway, moving on from that, obviously, first time you're going to really get involved with an expert is the point at which you're thinking of instructing them. Obviously, the process of instructing experts, that's not something I really see as a member of the bar. That's normally done before I get involved. And so I'm very sorry if I'm teaching you all how to suck eggs here. But there's a number of obvious things that I think we all know we need to get right when it comes to instructing an expert. You've obviously got to think about the logistics, turnaround time for reports, the costs. Is your expert willing to accept instructions? Going back to an earlier point, I think it's also worthwhile asking an expert in a very upfront way whether they are thinking of retiring from medical legal practice anytime soon. Lots of our cases drag on for months and years, and if your expert is a dusty professor who's been in the game for quite some time, very well respected expert, but they're thinking of going off into the sunset, into retirement in 6 months' time, you may want to avoid dealing with that expert, because you're going to have to grapple with their retirement later down the track. Obviously, when you're sending medical records to an expert, just make sure they're paginated in a sensible way, because that will save you time in the long run. Make sure that you, the other side, and the court can see what the expert is referring to when they put references in their reports, and it encourages them to put references in their reports. Consider whether there are any factual statements or provisional drafts of factual statements that you want your expert to see. Again, going back to a clin neg context, you may, if you're defending a clin neg case, you may have some draft statements from clinicians who were involved in an incident, and you may want to send those draft statements to your experts just for some background context. Equally, if you're for a claimant and you are, for example, alleging that there's been a failure to consent for a particular medical procedure, it would be useful for your proposed expert to have a draft statement from your client, just to see what they say they would have done if they had been appropriately advised of various risks of treatment. A point that I've got on screen here, and I will keep coming back to it because it's very important. Once again, a bit of a clin neg context, but it is relevant to PI practitioners, given that you will encounter clin neg issues in your practice at some point, is make sure that you remind your expert of the appropriate legal tests. So this isn't just, for example, that the court is the one who makes findings of fact on the balance of probabilities, but this is, for example, the but-for test when it comes to causation, and material contribution, of course, when it comes to causation, particularly when it comes to breach of duty in a clinical negligence case. You want to refer them explicitly to the Bolam test, which is on screen. I'm sure most, if not all of you, are very familiar with this. Don't just assume because you're intending to instruct someone who's very experienced as a medical expert that they have this at the forefront of their mind when they are writing their report. Really important that you put it on paper and get it to them. In fact, what I almost invariably invite experts to do is to transcribe the Bolam test, so to speak, if that's applicable in the case, within their report at the very start. The reason for doing that is pretty clear. It's a good reminder to them as to what the appropriate legal test will be. And of course, just moving over the slide, we've also got the Bolitho modification to that. And we've got reference there to Montgomery, which applies to consent cases. So not only does it remind the expert of the applicable test to be applied, but it also limits the chance of a fairly cheeky barrister like me standing up in a courtroom when you get your witness in the witness box and asking them, inviting them, just to explain to the court their understanding of the test, the legal test that they've applied when drafting their report. You'll be surprised how often that ties medical experts up in knots, and it can really damage their credibility at the outset of their evidence if they're not able to clearly articulate these tests, or at the very least point to their report and say, well, you'll see at the introduction of my report, I've referred to the test of Bolam. They can remind themselves of the exact wording of that from their report. That takes the sting out of that line of questioning. It generally completely nullifies it. So very important to invite your expert to include those things in a report. Now, once you get the first draft of an expert's report, it's very important that you obviously review that report, not just to see what they've said in their conclusion, whether they're going to get your case off the ground, going to give you any basis for defending a case. You want to go through it with a fine-tooth comb. At an early stage, review it with a critical eye and try and iron out any creases that there might be in that report. Say for the most simple cases where you've got quite experienced experts, I rarely find that a report is in a ready to go, oven ready state in its first iteration. Almost invariably, there are things that you'll want to ask the expert about. You'll want to get them to fill in particular gaps. You can hopefully limit the need for significant modifications by your letter of instruction to the expert, which, as much as time allows, it should be detailed, should flag up the relevant issues for the expert, and perhaps signpost the various points that you need the expert to address to help the expert structure the most complete report possible. But when you receive that first draft of the report, don't be afraid to go back to the expert, perhaps after a quick chat with counsel, with a series of questions or clarifications, and perhaps an invitation to them, for example, to address further issues, to expand on certain points, or to include legal tests, stuff like that. One thing that I hate to see is an expert refer to guidance or literature within their reports, and for that literature not to have been produced or provided. Now, I'll confess, when I do receive a medical report, which is perhaps 30 pages long, I think, well, I can read that easily. That's probably the extent of my concentration. If I've then got 300 pages of quite dense medical literature at the back of it, my heart does sink, and I'm sure you're all probably the exact same. But what I say is this: at some point, if they're referring to literature, you're probably going to have to grapple with it, and you're probably going to have to understand it. It's very important that you do that at an early stage. Now, when I say you've got to do that, I don't mean that you've got to read all 300 pages of it and understand every scientific term, every statistic that's used in that, or the methodology adopted in that literature. What I think it's important to do is to ask the expert for it. And when we come on to the question of a conference with the expert, this is the time at which you can say to your expert, right, you've referred to 10 peer-reviewed studies in your report. You've used these as the justification or the basis for your conclusions, or you've used NICE guidance as a basis for your conclusions. We've reviewed it. We think these are the relevant points that you're trying to highlight, but please walk us through this literature. Tell us, why is this important? Why is this in your report? That's important because it aids your understanding of a case, enables you to have a better appreciation of the strength of those conclusions that the expert is providing you with. And it also puts your expert under an appropriate degree of pressure to explain themselves, to explain why they put that in there. You want to ensure it's not just a throwaway reference, almost like a garnish to their report, which really doesn't add much and perhaps masks the fact that their opinion is largely just their impression of the case. So useful to push them on it. You doing that in conference is much better than that happening for the first time in a witness box at trial. On the issue of conferences, these are critical when it comes to getting the best from your medical experts. So where it is possible to do so, I say that you should have a conference with your expert or experts at an early stage, at the earliest stage you reasonably can do. The reason for that is you want to really front load your effort in a case. You want to get things right, get a solid foundation for your case, whether you're for a claimant or a defendant, so that in the latter stages of a case, there is a lower chance of any surprises coming back to bite you. So we'll talk about joint statements in the trial process in due course, but they're often, in my experience, the points at which things go very wrong if one hasn't done their homework at an early stage of a case. So an early conference is invaluable. You want to know whether it's a runner or not. You want to identify whether your expert is being balanced and objective in their written opinions. You want to ensure that they're not acting perhaps as an advocate for you. You don't want someone who's merely backing your position because they are instructed by you. Obviously, you want them to be clear-headed, level-headed, objective, and telling you what you need to hear rather than what you want to hear. It's unfortunate to say that some experts think, well, if I'm instructed by the claimant, I should write a report which is sympathetic perhaps to the claimant. They might not think that consciously, but perhaps subconsciously there is a degree of pressure on those experts who aren't perhaps the most impressive experts. Equally, those instructed by defendants might think consciously or subconsciously, I perhaps should be sympathetic to the cause of those instructing me. You want to be able to weed out those experts at an early stage. You want to know if you've got a bad case. You want to know if you've got a good case. Knowledge is really power in a situation like this. The conference is an environment which is safe, it is controlled, but it's an environment where you can be very frank with your expert and get your expert to be very frank with you. I find that a conference should be a pleasant experience for an expert, but they should feel tested in conference. They should feel that they've had to work in conference to explain themselves, justify themselves, stand up for themselves. As I say, it should be polite and measured, but one should put them to task to see and to test the strength of their evidence. A couple of other basic points in respect of conferences with experts, particularly at an early stage, is to consider who should be in the room. Now, when I say in the room, of course, a lot of us will be doing telephone and Zoom conferences these days, but what I mean is just who should be in attendance generally. You may have a case where you've got a raft of experts. Some of them may be useful to attend with other experts, and some might not. Some might be speaking to a very discrete part of your case, and there's not really much point dragging them to a conference to sit there for about 4 hours listening to the other experts yatter away about the meat of a case before adding something quite discrete and limited at the end. So think about who should be there. Think about the logistics of a conference. How unwieldy will a conference get? I personally had conferences for defendants in clinical negligence cases where there have been 9 experts in the room, and I've been instructed quite late in the day to attend those conferences, and I've been somewhat dismayed to see that there is that number of experts attending at the same time, when perhaps things could have been divided up into discrete compartments, meaning that the discussions were more productive and focused. So just have a think about that and be aware of how that will play out on the day. If you're acting for a claimant or indeed a defendant, think about whether you want the claimant to be in attendance, or in a clin neg case, defending, for example, the clinicians, whether they've got useful things they can add and whether they should add them. Now, when it comes to, for example, having a claimant there at a conference, sometimes that can be very useful for the claimant's purpose, because they will have an opportunity to hear the justification lying behind the expert's report. They can be reassured that things are being discussed in detail and everything's being considered as much as it should be. But equally, there may be particular cases where you think to yourself you would prefer to have a discussion with the expert alone, without the client being present, provided they're happy with that. Because you may find that you're discussing sensitive issues, and perhaps you may be worried about the expert not being as candid or as direct if the claimant is sitting in the room opposite them. So just have a think about the dynamics of a conference. I'll not labour the merits and demerits of various remote forms of conferences, because I'm sure everyone's probably sick of talking about COVID and working from a home office and the like. We all know that you can have conferences by telephone, by video link. They've all got certain deficiencies and logistical hurdles that need to be dealt with. But I'll leave all those types of issues for another day, perhaps another webinar. A couple of final points, but I think important points in respect of conferences. First of all, an agenda or a conference note can be very useful. In a simple case, it's not really that important, perhaps, but certainly I find that in the higher value, more complicated cases, it's very useful to have some form of agenda or note which helps direct the conversation, helps tee up the issues for everyone involved. My personal preference, particularly in a case involving clinical negligence allegations, is to have a Word document, but a Word document with tables in it which cross-reference dates, events, medical records, expert commentary, and then some questions that I have in a grid type system. Now that's not a one-size-fits-all type approach, but that helps me certainly to step back and look at a case in a holistic way, and helps order my thoughts when it comes to a conference, and ensures we don't miss out on anything or lose any context. I find that drafting something like that and sending it to the experts before the conference can be very useful, just so when going through the conference, if I'm referring to a particular date in the chronology, I can get them to turn to the relevant page. They'll see the relevant medical records that's recited there, perhaps an extract, a relevant extract of a witness statement or an expert's report, and it helps just draw all the strands together for everyone. So do consider whether it would be useful to have a note or an agenda for your conference. Ask counsel to draft it if you think that's appropriate, and feel free to have a crack yourself as well. It should be really without saying that we should remind our experts to reread their reports and relevant documents before a conference. I think that needs to be said quite clearly to experts. I've had a number of instances where it's been readily apparent to me on questioning an expert that they are not as familiar with the material as perhaps I would like them to be. That could be because they've got a very busy medical legal practice and a lot of their cases blend into one. The lines get a bit blurred. They can have a busy medical practice that they're trying to juggle as well. But there's not really an excuse for a medical expert who is commanding fairly significant fees to attend a conference not to have appropriately prepared for it, at the very least by reading their reports, other experts' reports, perhaps the particulars of claim and other relevant documents that you've flagged up to them in advance. Obviously, access to medical records is very important in particular cases. One thing I do find, which is surprisingly user-friendly with platforms such as Zoom, which we're using now, of course, is that when having a conference over this medium, I am able to share my screen and pull up digital medical records, and I can point with my cursor to various sections of them, and it helps actually focus and direct everyone's attention to the right record very efficiently, and that can actually be a really useful feature of a Zoom conference in particular. I think something that's also very important is that I will often recommend having a conference with an expert to my instructing solicitor in instances where an expert will have provided a preliminary draft report, and they will have said something which perhaps jars slightly or doesn't seem entirely consistent. So, for example, I had an instance recently, a PI claim, where a gentleman was injured in a certain way. It escapes me now in what way. And the expert went through in great detail the various restrictions and problems this gentleman was having following the accident, which had been ongoing for a number of years, appeared to be chronic, entrenched. A significant level of disablement was being described, and certainly from my experience, I was certainly expecting the expert to conclude that that gentleman was disabled for the purposes of the Equality Act. And to my surprise, at the conclusion of the report, whilst the expert was talking about this claimant's inability to engage into previous work, he concluded that the gentleman was not disabled for the purposes of the Act. And before any of you jump up and down, I do appreciate the recent iteration of the Ogden tables has slightly changed focus on Equality Act definition of disablement, but at the time that was the relevant test. So I had asked my instructing solicitor to arrange a conference to walk the expert through his conclusions, and of course without trying to push him one way or another, just to present to him again with perhaps fresh eyes what the test was of disablement for the purposes of the Act, and to just get him to remind himself of what he had described within his report in terms of degree of disablement. And he very readily accepted that he had perhaps failed to reach the conclusion that he should have on reflection. And he was very happy to amend that section of his report. Now, after a conference like that, when you've achieved somewhat of a breakthrough, because that conclusion from the expert could change the complexion, the value of a case quite dramatically, I think it's quite useful to send an email, just a short email to the expert following the conference saying, thank you very much for attending today. Just to remind you, what we discussed was A, B, and C. Following reflection, you accepted that X, Y, and Z were the case. We'd be grateful either if you could amend your report now or just keep that email for your records. What that ensures is that those conclusions, fresh conclusions that have been reached are, I suppose, solidified in the expert's mind, and also the expert has something to refer back to if you send them an email later down the track saying, now look, can you amend your first draft of your report, or do you recall the conversation we had? You can refer them to that email and it will just trigger their recollections of the conversation they had with you. So it's quite a useful exercise. So everyone, I'll speed up a little bit at this stage because I've only got two further kind of headings to touch on, and that's joint discussions and then the trial phase. Joint discussions, they always make me a bit nervous when I see that they're scheduled, because we all know that what looks like a good case on paper can go very wrong on occasions in a joint discussion. Some experts can go on a flight of fancy for completely inexplicable reasons when they're discussing a case with their opposite number. Some perhaps crack under the pressure that their opposite number brings to bear, and some just communicate very badly in the joint statement, and their conclusions look a bit garbled, not particularly impressive, and that can really alter the strength of your case, or certainly the way your case looks on paper. So they're always a bit of a nervous, anxious time for any litigator. And so what you ideally want to ensure is that there are fewer surprises or no surprises. Best way, in my view, to do that is to follow all the advice I've just given in the previous slides. So early conferences, ensuring your expert has applied the correct legal test, just making sure that you are confident, entirely confident in your expert's conclusions, the strength of them, the logic of them, and also how confident the expert is in those conclusions as well. If you've done all that preparatory work, then it's unlikely or less likely that you'll have any great surprises. I think, though, a couple of things that we always need to bear in mind. The first is the use of agendas. Now, I'll be the first to admit that agendas often are that part of a case. Certainly, in my experience, seeing cases develop, they're a thing which sometimes gets overlooked a bit, or perhaps not enough attention is paid to them, because we can all get lulled into a perhaps false sense of security that our experts provided a very clear, unequivocal conclusion in his or her report. We've had them conference, they've been very confident. And so we think, well, the agenda is perhaps less important because both experts are a bit entrenched, and it would be very unlikely anything's going to come of this, really. It's just another hurdle towards trial. That would be a very foolish approach to take, because agendas can really make a big difference in a case. I'll not go through all the kind of principles underpinning an agenda, trying to narrow the issues, all that type of thing. Shouldn't really be leading questions. They should be objective. There shouldn't be 100 questions when 5 questions would do. But at the same time, I think a well-drafted agenda can steer a conversation, or funnel a conversation in a way that certainly assists the court, assists the lawyer's understanding of the case, but hopefully will also mean that the expert's answers are funneled towards a point which is favourable to you. And that's what everyone's trying to do with an agenda. Some people do it in a more obvious way than others. But within the bounds of propriety, I think drafting an agenda, making sure you get it right, that it is detailed, albeit detailed in a relevant way, not verbose or full of prolix, but detailed, comprehensive, clear, just ensures that the expert's evidence doesn't narrow to a point. It's useful to do that. And it's useful to spend some time on agendas and to involve counsel where you think it's cost effective and right to do so. In addition to that, make sure that once you get the joint statement back from your experts, you go through it with a fine-tooth comb. Don't just sit on it. I know all of you, being conscientious, punctilious litigators, will probably devour a joint statement quickly upon receipt and pick up any issues that may crop up. But you'll be surprised how many people sit on a joint statement, don't really look at it for a while. They perhaps glance over it, but don't really delve into the detail of it. And they find later down the track, upon further review, that their experts actually said a couple of things that seem to sit uneasily with their previous evidence. And sometimes that's because your expert has changed position, their thinking has evolved. But other times it can be that your experts just got into a muddle. They've just failed to answer the question clearly or even at all. I had an example recently where an expert just had simply failed to type an answer to a number of questions. He had typed the first 3 words and then the rest of his answer was cut off. And this wasn't picked up for quite some time. And it just became a bit of a nightmare trying to ensure we got that expert to answer those questions and we had permission to rely on those answers. So think quickly and carefully about whether you need to get back to your expert and get them to provide some clarification if they've said something didn't mean to, or they have expressed themselves, or in a poor way, or they've included lots of typos, anything like that. So do be aware of the potential of doing that. So final, I suppose, slide I'll talk about very briefly. I'm grateful for all your patience up to this stage. This is the trial stage. This always the drama at the end of a long process, and it's perhaps the bit where things can blow up in a very obvious way in front of you. During discussion behind closed doors, you're not there, whereas at trial, you get to see your expert sitting in a witness box, and that's their time to either shine or explode on occasion, as I'm sure we've all had experience of. How to ensure that your expert's less likely to go down in flames in a witness box? Well, once again, follow all the advice I've mentioned previously. Lay the groundwork for your expert evidence with the good letter of instruction, the good selection of an expert, the right discipline, the right subspecialism, a reputable individual who comes recommended from colleagues, the right letter of instruction, an early conference with your expert, an ongoing dialogue with your expert in respect of their report and whether it needs amendments or revision. Just holding your expert's hand throughout the process is important. I've been quite alarmed in the past that I've encountered some experts who clearly are of the view that cases just never go to trial in their experience, and so they don't need to worry about the prospect of having to sit in a witness box and stand to their written evidence under cross-examination. It's important that you explain to them, whilst it is true that many cases do settle before trial, they need to be ready to justify their conclusions at trial. They need to essentially relish the opportunity to articulate their conclusions at trial, to be questioned, tested at trial. The experts who don't fear going to court are the best experts. So obviously check before instructing an expert that they do have some trial experience, that they've weathered that storm in the past. I also think it's very useful to have a pre-trial con at a late stage with your experts, if at all possible. Once again, if it's cost effective and appropriate. That conference isn't to talk about the case so much, because hopefully by this stage, your expert evidence has settled and it's resting in a position you're comfortable with and the expert is comfortable with. This conference is essentially an opportunity to talk the expert through the trial process and reassure them. Now, you may raise an eyebrow about this and think, well, if I've got an expert who's gone to battle at trial many times before, perhaps I don't need to do this. And that may be right on occasion, but I find that most experts do take great benefit and comfort from having a conversation with the legal team prior to a trial. Helps reassure them, helps just give them confidence and puts a bit of confidence into them and a bit of backbone into them, that you're confident in their conclusions, you are confident that they'll come across well in evidence, and that they're well prepared. Giving them that reassurance means that they are more likely to sit in the witness box and give the best evidence possible and the best account that they possibly can. You'll see the final bullet point there I've got is make sure that you think about the logistics of the trial. So for example, there may be occasions where it is cost effective and right and important for your expert to sit through some of the factual evidence in a particular case, just so they can see it, perhaps even just to get a sense of what's being said by various witnesses, because it will inform, or may well inform, what they say in the witness box. I appreciate we're always struggling with the costs of litigation and with the availability of our experts, and so this might be a challenge at times, but as best or as often as this can be done, I would recommend doing it. So that's essentially the end of my talk. Last point to make there is that experts do carry the weight of expectation, weight of responsibility of their shoulders. They often come across as being quite confident individuals. Perhaps they're used to being listened to in their clinical environments. They're used to being top of the tree and respected and deferred to. But in my experience, most experts, when they're taken out of that context and they're put in the litigation process, even if they have done medical legal work for many years, they can sometimes get a bit anxious, a bit worried, a bit uncertain about what they're doing. So I think it's important that we assist experts, help them, guide them, hold their hand, and enable them to give the best evidence that they possibly can. So everyone, thank you for bearing with me, having the patience to listen to me whittle on after a bank holiday weekend. I know it's probably not easy. I'm glad to see that I haven't shed too many participants over the course of the past 45 minutes, an hour or so. What I have done is I've taken off the slides, you can probably see. I'm going to hit the Q&A sections to see if there are any questions. At the moment, there don't seem to be any questions on my screen. But if you do want to email me about anything that's arisen in this talk, any general points or specific points about files that you have, concerns that you might have, I'm more than happy to respond. And there's no obligation, of course, or no expectation that that means we'll necessarily be speaking again. It's an open invitation. Great, so still no questions as far as I can see. Okay. Still none. Right, guys, I think I've probably waited as long as needs be. As I say, open invitation to email with your questions if you want. Thanks for attending. There will be more webinars, I think one every fortnight for Farrar's building. So do feel free to attend future events. We're always grateful for the opportunity to speak to you.